Good evening, everyone, and welcome to another edition of our Justice and Pieces series here on meeting the paralegal venture candidates. Again, as always, the views and opinions are of the candidates alone and don't reflect me, Justice and Pieces, Trias College, or any other institution or organization I'm affiliated with. Now that we got that out of the way, I'm really happy to conclude this week with Shaun Harvey joining us. And I think now we've heard from almost half of the candidates. So thank you so much, Shaun, for joining us. And maybe you could start by just telling us a little bit about yourself.
Sure. So, Shaun Harvey, for those of you who don't know me, I've been a paralegal since 2013, practicing primarily landlord-tenant and small claims, like most of, a great many paralegals. Many of you might know me as the author of Case Law Ninja, caselaw.ninja, the encyclopedia that I published to help those, improve the research and speed up the research process. I 10-second history of me. I graduated from the University of Waterloo back in 2012 with a degree in sociology and legal studies, and I got my paralegal postgraduate certificate from a combination of Conestoga College and Seneca. So between the two schools, I finished my program. I've been practicing for almost 10 years now. I have 4 associates, one business partner, and that's sort of my professional history, if you will. I'm not sure what else you want to know.
No, that's great. I guess, and I think maybe you're a decade apart, but I did go to the University of Waterloo for sociology many moons ago. So maybe after we're done, I can chat about some of the hot spots there that I remember in the university days. Now, Shaun, maybe you could tell us now, why are you running for paralegal venture, and what was sort of the thought process in putting your name forward this time around?
So I've been actively engaged in the paralegal community for at least the last 5 years, pretty consistently. And the biggest issue that I think is common ground for all candidates, regardless of who you are, is the question about scope of practice and our ability to serve our clients. That's the big hot button issue for everybody. And I believe that we all want the same thing. We want the ability to serve our clients and to provide access to justice. Access to justice is something that is a concept that is a little bit fluid in the legal community. I put out a study, or I put out a survey to about 10,000 people, 40,000 people. And I asked, what is access to justice? And I got about 300 or so responses. And depending on whether all the paralegals that responded answered completely consistently, which was access to justice was expanded scope. However, when the lawyer candidates answered, it was much broader. It was things like timely access to the courts. It was things like cost. It was things like better access to legal aid. It was mostly about procedure, like how to get to justice. And I think that one of the big things that I believe that I bring to the table is a level-headed and sensible approach to the problems that we face. The problems that we face are not lawyers are out to get us. They're not that somehow we are not good enough. The problems that we face are about setting standards that make sense for our goals. What I bring is a perspective that I think is vastly different from my peers, which is that this issue about scope of practice and about governance isn't really about paralegals at all. It's about how do we want the law society to govern the provision of legal services. I was reading a thesis on the question about effectiveness of the law society in implementing the paralegal regime, and it was a study done over 8 years, quite a brilliant article. And what I found most interesting about it was that the current model or modality of the provision of legal services is premised on it is better to have the Cadillac or no car at all. And there is this notion that there isn't an in-between or shouldn't be an in-between. Paralegals, when we entered the discourse formally in 2006 and informally in 1980, the alternative to lawyers represented this idea that not everybody has to spend a decade in school. It's going to lock my door. Not everybody has to spend a decade in school to address questions that you can be trained adequately on in the field or through some amount of education, whatever that standard may be. And the question about standards and access is really about what does the public need? And the public needs capable professionals who can help them navigate the system and help them obtain results that they are lawfully entitled to put their positions forward and to advocate for them. That's what the public needs. They need to ensure that when they hire someone, they are accountable, that they are insured so that in case they make a mistake, that they are protected from damage. And that's what the public needs. So the question is, when we look at the role of the regulator, it's how do we ensure that the public's need for legal services are adequately provided in a way that takes into account the diverse socioeconomic backgrounds of all Ontarians, of people who are very poor, very rich, and for the vast majority, somewhere in between. And the question comes up, why are paralegals important? And why is their expanded scope important? Why do we care about that? And I think that to answer that question comes down to diversity. Out of 2,000 candidates that apply to any given law school, approximately 99% of them will be rejected. And that's just because of the simple fact that there are only so many first-year seats. It's a simple numbers game. There are only 15 law schools in Canada, I think. There might be 17 now, I can't remember, but there isn't that many. There's only so many that graduate in each year that will enter the profession. And through no fault of anyone, there's going to be a lack of diversity of culture, diversity of experiences. There's going to be a lack of diversity of every imaginable kind, because how can you not with that kind of restriction on input? It's a function of reality. The paralegal initiative really is about creating opportunities for more diversity in the legal profession, creating opportunities for people from a variety of backgrounds, countries, cultural experiences, to bring all of that knowledge and wisdom to the table and say, I have something to say and it matters. I can advocate for people that I can support, people who speak multiple languages, people who have a particular affiliation. The paralegal initiative matters because it is not enough that lawyers have skills. It comes down to numbers. There are other systemic barriers that prevent people from achieving the status of becoming a lawyer that have nothing to do with capacity. Economics is only a small part of it. I'm a father of 4 children. 3 of my children are autistic, highly functioning, but autistic. And I can tell you that my ability to drop everything that I'm doing and go back to school and get a JD, even though I have a bachelor's, would be unsustainable. And I consider myself quite bright, but that doesn't change the fact that my obligations would prevent it. But my experience, like so many other people's experiences, allow us to bring a unique perspective to the world. I have a history of taking on crazy cases. I have a history of taking on cases that are, some will say, out there. If you Google my name, you will see I've done some couple of kind of crazy things. And it's all over Canley. And I'm okay with that. I own that. Because I have the courage to try things that are new. I have the courage to try things that are novel. I know it's repetitive. I said the same thing. I have the courage to follow through with my conviction wherever that takes me. And sometimes I get before the Court of Appeal on a personal case and I lose. Maybe I apply. Sometimes I work with other lawyers and I work with lawyers and in the background and try to craft cases that go to the divisional court. And sometimes my ideas are out there, but I believe in them. They're important. My clients are important. So I follow through. And what no one can do for you is argue your case. Nobody can argue your case better than you can argue your case, the one that you started, the one that you believe in. Because you know the facts, you're emotionally connected to the people, and it's in you, it's in your brain, and you're prepared to deliver because it's your message, your theory. I can tell you that I've learned the rules of civil procedure. I understand them. I can tell you that I've written dozens of factums. I've perfected dozens of appeals and then handed them off to lawyers to approve and submit with very minor to no edits. What's the moral here? The moral is that it isn't a question of whether we have the capacity to learn. Of course we do. We all have the ability to be better paralegals or better legal professionals. We all have the ability to learn a new skill set. The question that needs to be answered, that needs to be put to the Law Society is, what kind of society do we want to endorse? What kind of society do we want to be the leaders of? And for me, the Law Society is one of the most noble and respectable positions in the province. It's right up there with the College of the College of Doctors and Physicians. We are as important as we are to the medical profession. Sorry, we are as important as medical professionals are in terms of safeguarding our society. We safeguard democracy and our rights on the ground. The Law Society is very old. And old does not change easily. It comes hard fought. But in a modern era, in a trans global society, where we don't even need to be in the country anymore to attend a hearing. I could be in Bangladesh, Australia, Japan, Mexico, the Bahamas, doesn't matter. We live in a society where justice is more important than ever. The complexity is more important, is more complex than it's ever been. And the only way we're going to tackle that is by taking on a new approach to the provision of legal services. And that comes down to diversity of voices. What is the argument to why paralegals should enjoy an expanded scope of practice? It isn't because I wanna make more money. I wanna serve my clients better. So what? No, that's not why. That's the effect. The why we do it is because 100 law school applicants does not compare to the amount of people who can apply to an expanded program. It takes a lot of energy and money and resources to run a law school. I advocate for an expanded licensing model where you start with a P1 and you have the opportunity to improve your skills and abilities and write supplementary licensing which specializes in particular areas. Now somebody's going to say, that's crazy. That's, what I don't want to have a myriad of 16 licenses I have to get to practice. That's insane. And that's a position that you're going to hear a lot as we debate these issues going back and forth. But here's the reality. Here are the facts on the ground. There are 10,000 and change eligible paralegals to practice right now. It takes 1 year to graduate a program. It requires absolutely no prerequisites. You can go to Trias or any of these schools and without any prior educational background and graduate. And I have no comment on whether that's good or bad. That's just, it is what it is. And then 6 months later, after you've gone through the process and got the licensing and wrote the exam, you can practice. Well, compare that to the average lawyer. 4 years undergraduate on average, 3 years in law school, 1 year of articling, 8 months plus waiting, plus another year in between for all the transitioning. From the beginning from the first day you attend your undergraduate to the day you get your license in practice, it's about 9 years. Of course, the average lawyer is better prepared to think critically, to analyze, and to take on complexity. Of course they are. that spent 9 years studying before they get to day one. The average paralegal, 1.5 years. Now, there are exceptions. There are people like me who come into being a paralegal with a degree. There are others that have PhDs. There are others with master's degrees. There is a vast amount of exceptions to the rule. But policies are not written to the exception. Policies are written to the mean, or policies are written to the mean, to the average. So it doesn't matter that somebody has an exception. The question is, what makes good policy sense? What protects the public on average? What is the basic standard we are prepared to accept as a society, as a profession, for an entry-level professional? And what I would say is that the supplementary licensing solves a fundamental problem, which is that diversity of educational background with existing paralegals has to be addressed. Even if we change the standards tomorrow and we said everybody has to have this, if the standard is at level 1 right now, just some arbitrary number, and we say the new standard is going to be at level 6, and then because everybody's at level 6, everybody is entitled to practice, whatever, immigration, divisional court, simplified rules, whatever, right? The problem is it doesn't address the issue of, well, what do we do with the existing 10,000 paralegals who didn't have to go to level 6? Do they just inherit that? And how does that protect the public? It's certainly great for our pocketbooks as existing paralegals. I would love it. I would love to be handed everything, just like I'd love to win the lottery. But that doesn't mean it's a good idea. The specialty licensing model deals with the issue of protecting the public from the unknowns. The fact is, the Law Society is to blame for our current standards. The Law Society sets the standards. They decide what the education requirements are going to be. They decide what schools are allowed to teach. They approve the curriculums. They make those decisions. We are a product of those decisions. What we want is the ability to serve our clients. But we have to do it in a way that honors the original point of our existence, which is to bring a diversity of perspectives that cannot be brought because of the fundamental choking point, which is law school entry. The numbers don't add up. I would like to see, higher standards. Personally, I think of paralegals could be akin to nurse practitioners in the medical world. Where there's certainly, in the medical profession, if we use that as an analogy, there are 3 fundamental levels. You have registered practical nurse, registered nurse, and nurse practitioner. And each of those levels have different scopes of practice that's defined by their bylaws. And each of those scopes have educational requirements that have to be met. To be a nurse practitioner, you have to have a university degree and a certain amount of experience. And you have to work under a professional who will certify that you have indeed learned in the field those skills. I understand the challenges that we face. There's only 3,500 or so practicing paralegals. It's a challenge. We don't have big, giant law firms that will take on 15 or 20 students and like downtown firms in Toronto will. We don't have that in our profession, in our sub profession, if you will. But if we're going to move forward, the only way we're going to do that is to work within a framework that stays true to the primary function of the Law Society, which is to govern the provision of legal services for the protection of the public. What I bring to the table is dialogue. I understand what the concern is for wanting to just allow somebody to do something without any thought or consideration. Take immigration. It's a really hot button issue these days. Are we allowed to practice? Are we not? Is the Law Society, misleading us? Let the courts sort it out. Just for fun, I did a little bit of research in what was required to become an immigration consultant. I wanted to know, what are the standards set by the federal government? And it used to be there was a college program. You take the college program, graduate the program, write your license, be done with it. Similar to a paralegal. Recently, however, they have increased their standards. As of now, only the University of Queens University, offers the program at a graduate level, and it's under the graduate studies at Queens University in the Faculty of Law. The standards are way higher than they used to be. This is new, brand new. There's something to be learned from that. Whether you agree or disagree with the idea that we should be able to practice immigration, personally, I take the position that if you have the skills, knowledge, and ability to defend an application, you most likely have the skills, knowledge, and ability to draft one. It logically flows. But I understand the fear. Whether the fear is rational or not, that's a political issue. But I understand it. And I think that as a bencher, what I bring to the table is the ability to help navigate not only the facts, the desires, but the technical, emotional minutia of getting crap done. It's about being persuasive. It's about having good reasons for wanting something and not just the desire. If I'm going to stand there in front of 40 lawyer benchers and 7 lay members appointed by the Attorney General, I need to be able to stand there and say, not only do we want amendments to the family law license, do we want to create a expanded regulatory regime, which will no doubt have expanded cost. That's going to be a criticism. It's going to cost more money. Why do we want to increase our fees or whatever else that may or may not happen? I don't know. Well, the question is, why are we here? And the answer is to serve the public. So let's bring a diversity of voices. And I think that paralegals are our best chance at bringing diversity of voices to the legal profession. So I don't know, perhaps I should stop talking and give you a chance to ask me questions.
All right, Shaun. So, well, thanks for kind of giving, a nice overview, I guess, as well of kind of the one of the areas of if elected, your focus is. Now to that sort of licensing regime, I mean, certainly maybe you can expand a little bit on on kind of how it would look. But if you've listened to some of the other candidates, yesterday as well as earlier this week, to your point, they would say, well, look, I have a license. I'm required to be competent in the areas I practice. Now, you mentioned, landlord, tenant, small claims. A paralegal could switch from that to do, let's say an obscure tribunal. Again, the Law Society's focus is, hey, let's get out of the big three. Any of the other candidates, any of the other paralegals can do that. And you may have learned, back in whatever school, public or private, about that tribunal, one class maybe, right, in tribunals or administrative law, and you're able to do that, right? So now with immigration or family or divisional court or whatever other areas, the point being is, if we can do that and we're required to still be competent, the rules of professional conduct, why do we need additional education? Shouldn't it come from experience and professional development? Is there a need there to what you're saying is additional licenses in different areas? Should it come from within the Law Society rather than going to school or going wherever to get those education needed to then get another license or two to practice in a different area?
What we face is not a practical problem. It's a persuasive one. I told you earlier that it takes an average of 9 years to go from undergraduate to lawyer, an average from 1.5 years to go from, hey, I think I want to be a paralegal, to, hey, I got my license. There's a certain amount of educational snobbery that comes with obtaining higher learning. It's the kind of snobbery that you only understand it if you've done it. Because the whole point is you don't know what you don't know. Right? The Dunning-Kruger effect or Kruger-Dunning effect. I program as a hobby. I enjoy programming. I know a little bit of Python, a little bit of Java, C, a bunch of languages. And if I have a particular puzzle in front of me, I could figure it out. I could look up the algorithms. I could figure out how to do it. But I could never develop Windows. Yes, we as professionals have a toolkit that was given to us that we are, quote, competent in within that toolkit. But the competence is not absolute. The competence that we have is defined by the standards that were set when we started. We are competent within the boundaries of those assumptions. But the expanded scopes of practice were never contemplated in those original boundaries. So just because I'm competent to pass the Law Society exam for paralegals doesn't mean I'm competent to pass the Law Society bar exam. Now, I might be able to take the bar exam, and Lord knows, it'd be kind of cool if they just let anybody challenge the exam. That'd be nice. But I digress. Competence isn't a moral judgment. It isn't how good or bad you are, or how smart or dumb you are. Competence is about whether you have the requisite demonstrable skill for the standards set by whoever is setting the standards. And we are competent only within the boundaries of the original standard framework. The moment you want to go outside of that framework, the standards shift. As a whole, there's a reason why the barrister exam and the solicitor exam are much more comprehensive. So we are competent insofar as the standards that were set for us. But once the standards shift, that argument no longer holds water. Once the standard shifts, we have to reevaluate how we view ourselves and how we view what we bring to the table. Does that answer your question?
Well, I guess, I mean, like, for example, there are some schools that have an immigration course that's about the same length as a tribunal course, or no, a criminal or POA one. And because again, I see this brought up, from others that are running that, hey, I've taken this course. It's prepared me. Obviously, I could go to the Immigration Refugee Board, and as you brought out, well, hey, if I could do the board appeal, why can't I do the application itself without the need for a further license, in immigration, or even like a denoting it on your P1 that additional training to practice. However, you may envision this looking like, but I guess the question is in terms of what types of additional, or what it would look like, right, in terms of what you would propose, whether it's family law, whether it's immigration, whether it's divisional court, whether it's expanding criminal, whether it's expanding anything else, wills, estates, you name it. What I as a
Real
lawyer
estate.
can do that you can't do as in your scope as a paralegal. Well, what would that look like if elected, right? If you're saying, look, we got to convince the lawyer bencher candidates and the lay, like, even if the 5 paralegals collectively said, hey, we want all this, well, they still got to get 20 odd more
27.
votes, yeah, to get to that number, right? They got a 22 more to their 5, assuming they're on the same page. So what would you say in terms of being persuasive to those other benchers? And again, there's slates and independents, and we don't know how it's going to look like in the end, but what's your model there in terms of getting this additional education that you're saying is going to convince them, and maybe not in the next 4 years even, but over time, as you've mentioned, resistant to change? Hey, this is why in the public interest expanding the scope makes sense, as well as we're not putting an issue of competence before us, right? That, hey, someone could just write as you said, write an exam and be licensed. So that's all they have to do. They pass this exam, and now I'm a lawyer or I'm a paralegal. There'd be questions of, are they competent now to represent people, right? So what would you sort of propose or envision in terms of how this sort of licensing process would look like for additional areas of scope?
So where I would start is, once elected, I would be making phone calls to every single one of the lawyer benchers, all of them. And my first and most important goal is to build relationships with whoever is elected. It doesn't matter who they are. I don't care if they're slate, non-slate, good governance, or full stop. Doesn't make a difference to me. My loyalty is to the paralegal profession insofar as that's it. My loyalty is to the paralegal profession, with my overriding obligation to the public. But I would start with relationships. I would start with talking to each of them as often as I could within the boundaries of time constraints, and exploring the question with them: what's it going to take to get to yes? What's it going to take? What do you need to hear to get you to a point where it makes sense in your head that you can vote for this? And I have some ideas of what that will take. I have some notions of what it will take. But at the end of the day, I won't really know anything until we figure out who's on the table, who the players are. Some people are more open than others. So I start with that. I start with relationships. I start with what are their current positions? What are the principles behind why they hold those positions? And can those principles be taken into account? Can we accommodate their fears, their desires? Can we accommodate their concerns? Can we cover them off? My goal is to work through those experiences and find a path that gets us there. What does alternative licensing look like? It's a little bit unclear. I have some preliminary ideas, but as they say, no plan of battle survives contact with the enemy. No litigation plan survives contact with court. You go in thinking I've got all my questions lined up. You go in thinking I know exactly what I'm going to say. I've got my evidence ready to go. And then you get there and all of a sudden, bam, somebody brings up something and it just derails into something you were not expecting. I go into this with an open mind, with an eye to the question of how do I learn about, I will get us to where we want to go. Given the opportunity, there are no certainties, there are no guarantees in life. But what I can say is this, is I will commit myself to finding the path to get us there. And although there is uncertainty about what it will look like, I'll get us to the best of my ability. I will get us there. Having children that are neurodivergent, my 3-year-old and a 4-year-old autistic, and my daughter who's 12, I've learned a lot about challenging pre-existing ideas of how the world is supposed to be, how kids are supposed to act, what is normal. How do I convince my teenage daughter to, go to school? And it's about taking time to get to know her, understanding the fears, the desires, the concerns, and then helping her align those fears, desires, and concerns with the overriding need of go to school. The Law Society isn't that much different. Dealing with other benchers isn't that much different. Benchers have concerns. So whether we're competent or not competent, whether I can make some highly technical argument, which I can do all day long. But this election, this change isn't going to be won or lost on technically precise argument. It's going to be won or lost on how comfortable people feel. The arguments matter. The technical stuff matters. It sets the table. It makes it possible. It creates a framework where it can be logically debated, rationally explained, and rationally justified. But that final vote that gets us to where we want to go, that's not a rational vote. That's an emotional one. How do I feel? What does my gut tell me? Does this make sense? Does it reconcile with everything I know? And that is where relationships come in. Do I trust the person putting the agenda forward? Do I trust them to carry it out? Do I trust them to honor its process? Do I trust that it won't break the system? That it won't compromise my needs, my friends, my professional obligations, and those who put me in office? Do I trust that? So I don't know if that answers your question.
Well, I mean, in terms of trying to convince get those 27 votes, right? Again, whatever we're looking at, pick an area, if it's immigration, family, wherever you're seeing as you're mentioning scope. No, on one hand, you're saying, look, well, if we just say, look, just let us do it. We already have the license. Tomorrow we should be able to go into court, family court, or whatever this passes, and maybe do some professional development hours. You're saying, well, hey, that's not going to be very convincing to those 27 people, because they're going to have questions of, well, what education do you have, what experience do you have, et cetera, right? But I mean, on the other hand, it's, you're saying as well, going to law school, there's sort of a barrier, right, in terms of time and costs. Well,
not just time and cost, but access. Remember, 2,000 applicants, 100 positions. So
Right.
even if you take into account the fact that, let's say their time is no object and money is no object, there are still only so many spaces. And that's an access issue too.
Right. So I'm saying that, no, you can't go to, like, for whatever the reason, right? You're not unable to go to law school. You go and get your paralegal license, but then you're now going to have to do an additional license that's going to take some time or some cost or even spots, right? I mean, it's not like, if it's done either through the Law Society or through certain schools, like you mentioned, Queens, right? I mean, that effect is there too, but isn't that going to create some of those same issues, but now after you have a license as opposed to getting your license?
So the role of the regulator is not to make the professional's job easier. The role of the regulator is to make sure that the basic competence of its professionals are met and to ensure that they are adequately disciplined as necessary and provide recourse for the public. It is not the job of the regulator to make it as easy as possible for somebody to practice in our field, just the opposite. It's the role of the regulator to ensure standards are met. It doesn't matter that I'm a father of 4, and I may need to, in my model, I might have to take a semester of night classes and do some courses. I might have to work under the supervision of somebody for 6 months to learn a skill, to make sure that I understand the process properly. Right? I don't know. I don't know what it looks like yet. But there is a 0% chance that I'm going to convince 27 people to allow 10,000 paralegals to just enter a brand new area of law without any kind of upgrade. There is no way that is rational, because the diversity of background of the various standard skills and experiences of those 10,000 people is so vast that it makes no good policy sense. I cannot make a good policy argument as to why that's a good idea. I can't.
But then what's the idea of where do you go in terms of, okay, so you're saying it can't be nothing, right? I mean, other candidates have said this is sort of where we see it. But how, or kind of outline, let's say, again, 6 weeks from now, you can be elected as a bencher, and that starts that process of, okay, now in the public interest, in the paralegal profession, we feel that, we need to expand our scope. How do you start then that day and that, your term of convincing those benchers that here's the additional standards that we're going to put in place that we propose to allow this scope to expand? What would that, I mean, again, you don't necessarily have to have all the details, but sort of generally, what does that look like? Because you need their vote, right? You need, I'm going to talk to some of the lawyer benches, hopefully all of them candidates over the next few weeks as well. But what is it going to take for whoever is elected to say, Shaun, I back that, and then back the expansion of scope. I like this plan of instituting additional courses or education from schools wherever. But what kind of, in terms of generally, would that look like to get that vote?
So on ShaunHarvey.ca, I outline a basic proposed model of what an expanded scope, an example of expanded scope license. It's not necessarily definitive, but it's an example. So in my example, I have, let's say you have 5 years, and I picked it somewhat arbitrarily, but let's say you have 5 years of field experience. With 5 years of field experience, you might have to do a semester, 1 or 2 courses. to learn a particular area, like the rules of civil procedure, for example, or whatever. And then you would write you would write an exam, and then you would have the additional license. Or, for example, you might have, if you don't have an existing license, we might have an opportunity for, say, a 3-year degree program for new licensees, not existing ones, but for new licensees, where instead of going from P1 to P2 or whatever the regime is, you can get all of it if you do a 3-year program instead of a 1-year program, as an example, where we keep the existing P1, but we have the reality is, if we have alternative scopes, the schools are going to capitalize on this. They're just going to. It makes good business sense. Right? Whatever the maximum you can give your students is what the schools are going to do. And that's just reality. So if you have a 2 or 3-year program, it says when you're done the 2 or 3-year program, you can practice, instead of this big, it's going to be this big. Well, what's the rational student going to do? Well, barring time and money constraints, they're probably going to do the bigger one, right? Someone might say, well, if I wanted to go to school for that long, I just become a lawyer. Well, my 3-year program is still shorter than your 9-year to become a lawyer. So, don't talk to me about I would just become a lawyer. It doesn't make sense, right? My model that I'm proposing is still faster. It's still more efficient. And it ultimately allows for that expansion. Does that answer your question?
Yeah. So, I mean, I guess, there's, for anyone else that's listening, that, they can go to your website there and sort of see kind of that framework in place there. And again, obviously subject to, being elected and looking at it more and working with, the other benches and so forth, what can sort of go from there to sort of more specifics. Now on that, I guess, I don't know if there's anything else you wanted to highlight, but essentially we're almost out of time here, but maybe you could tell anyone listening, especially obviously the paralegals that are able to cast a vote, why should they cast a vote for Shaun? And if there's anything else you want to touch on that we didn't get a chance to talk about, here's the time to do so.
I spent the last 5 years of my professional life contributing to the community as a whole, to devoting my time, my energy to mentorship of new paralegals, to developing Case Law Ninja, the encyclopedia. I devote myself to the process, to following the rule, to following the rabbit holes where they take me. I bring with me an energy that gets me to where I want to go, and in turn will get us to where we want to go. The reason you should vote for me more than anything else is that I have a proven history of contributing to the community. I give of myself regularly, and you can expect that I will continue that pattern of behavior. You can trust my history because I've proven that I am here to support the profession. You should vote for me because I can get us where we want to go. And that's the bottom line. I can get us where we want to go. And that's why.
Perfect. So Shaun, the last question here for those students that are listening that aren't going to be voting, and any words of wisdom, any final words of wisdom for them, as they go through, whatever the process that the future will hold, in terms of getting licensed and practicing and whatever the areas, hopefully more areas that they can practice in. And thanks again so much for taking the time and joining and speaking with us today.
My advice to students and to those who are just finishing up their program is a couple of points. One, be curious. Explore every question like it matters, because it does. Remember that the legal profession is first and foremost a sales job. And if you can't convince other people to believe in you, then you're never going to convince the court. So make sure that you believe in yourself, and that will come out in your ability to retain clients. And lastly, introvert or extrovert, reach out and form relationships. Ask questions, post online, make phone calls, ask for help. The more relationships you form, the greater your opportunities for success. Relationships will be the singular most defining feature of your career. So build wisely and build a big network. It will make the biggest, most significant impact on your career. So.
Perfect. So thank you again, Shaun, for joining us. And for everyone listening now, we've heard from 9 of the candidates, and the ones on the Good Governance Coalition we'll hear of individually coming up in the weeks to come there. So again, thanks for tuning in, and we'll be back on Tuesday next week with this series. We have another guest, Monica Basso, there on Monday, talking about her practice, like how we've had in the past with some of the lawyers, paralegals, and other members joining us. So a little break there from the paralegal candidates, but we'll continue on next week there. So check on LinkedIn or wherever for the upcoming schedule. And once again, thanks, Shaun, for taking the time and joining us. Take care, everyone.